And then we would have the hearing in that room. Some states, take Ohio. Ohio has federal court houses all over the place. I think it's due to their population of 10 million people and having a lot of members of the House of Representatives, far more than Maryland does. We only have one U.S. District Court.
I see.
So if, I'm sure there's some other states that would have only one U.S. District Court. So if that was, say, like in the District Court was in Des Moines, Iowa, and your case was in Sioux City, 300 miles away, we would not have the hearing in the federal courthouse.
I see.
We favored the federal courthouse because it had the most plush conditions, and we had clerks waiting on us, and that was just great. Our least favorite was to hold it in a motel, which occasionally we had to do. It just wasn't some little town down in southwestern Virginia or in Pikesville, Kentucky, where the one courthouse was occupied, one courtroom. We'd have to have it occasionally in a motel. We didn't like that, but we would do it.
Well, it was a very exciting and interesting career, much more so than the usual judge.
It was, and most of that time, from 1975 to at least 1982, first 7 or 8 years, our per diem was $50 a day. That was for the motel and your 3 meals. Well, in the early years, from 75 to 80, most places we could find a motel room for $25, $27. And then eat a light breakfast and a lighter lunch, and then eat a $8 dinner, and you thought you were going real good.
Yeah.
But as the years went on, the government upped the ante a little bit for that per diem, and it never got adequate. It kept falling behind all the time.
So it cost you to be a judge traveling around the country.
It did, in fact. Thank goodness in New York, they finally put about 8 judges in New York to handle cases in Newark, Metropolitan New York, and Long Island. There's so many cases up there, so many disputes. I was amazed to find the number of small non-union manufacturers in Long Island and Newark in those sections, mostly work done by Puerto Ricans and immigrants like that. And I thought New York was big business and big companies, but it's far from that. It's still a real melting pot.
Well, yes, I know. It's very interesting. And now, when did you retire?
March 1987.
March 1987. And you started serving as a labor attorney, really, when they called you over the phone, and you went to work for 557 Teamsters.
That started me representing.
And what year was
unions.
that?
That was 1950, 51.
1951 to 1976.
1976.
So it was 25 years.
Yep.
A continual labor service.
Right.
So you really learned a lot about labor in 25 years, being a lawyer and a judge, not dealing with nothing but labor cases.
Most of it was very pleasant, Everett, but I remember the Painters Union called me over about 1957. They were not one of my regular clients. I had never represented them before. The word represent is the one they don't like.
I understand.
I'd never been their attorney before.
Right.
They called me over, and their problem was this. The companies were starting to use rollers, and not the old conventional 4-inch brush to paint walls and ceilings and things like that. But worse than using rollers, which they were against, because a painter with a roller could do about twice as much work as a painter with a brush. Of course, the painter union official said, we're not against the roller because it does more work, but it doesn't do as good a job.
Sure.
So now they had come along with extension handles to put on that roller handle, so that one painter could stand over like that wall there, and he could stand 6 feet away and do the whole wall. And then he could do the ceiling, put on a longer handle. Well, they wanted me to go to court and get an injunction against the use of extension handles and rollers. It so happened the week before I'd read a labor case out of Michigan, where the Michigan Painters Union had gone into the Michigan courts to get an injunction against the painting contractors and using rollers with extension handles. And the companies had brought in housewives who tested. The union claimed they were unhealthy. They were a danger to health, those with the roller on them. which was, of course, very weak.
Yeah.
And the company brought in housewives who testified they had been using rollers for 2 and 3 years and it never affected their health. And they'd used extension handles. Well, that was the only time I ever told union members, you can't hold back progress. I mean, flat out, I told them that. They wanted to throw me out the window on Gay Street, and there were streetcars in those days going down Gay Street. And it was a hot summer evening, and the windows were open, and big windows in an old building, and they could have thrown me out of there. There was enough room. But anyway, they agreed with me when I told them about the Michigan case that had already been tried, and they had no chance. It would be very bad public relations, and they agreed with me. And
they were fortunate you told them up front. I mean, you could have taken their money and gone to court.
I could have, yes. Yeah. At various times, I took some losers, Everett, where I would tell the union official that there was a case in the NLRB or the United States Circuit Court of Appeals right on the point, and they would say, our members want action.
Yeah.
We've got to do something.
Yeah.
Okay. Only a year from now, don't come around and tell me I gave you bad legal advice. I had a very good relation with just about all of the union officials. As I say, in Baltimore, they were realistic guys. And I was the attorney for the Maryland Telephone Operators Union from 1960 to 1976, and Cosmo Abato and his brother Tony are still the attorneys for that. Well, they went with the Communication Workers of America after I left. And they're still attorneys for that group of operators, and doing a great job for them. It was funny, that independent union was the only one I ever heard of, Everett. There was a corporation.
How about that?
It was founded in 1937, and the telephone operators are all ladies from Berlin, Maryland to Oakland, Western Maryland. They had had some business lawyer incorporate them. And I never could figure out why, because a union can be sued or sue with the same rights of any corporation. But anyway, they did. And it was interesting representing those ladies, I'll tell you.
I'll bet it was. I'll bet it was. Well, now, you are now an arbitrator.
Yes, after I retired from the board, I applied to the American Arbitration Association and the Federal Mediation Conciliation Service, and I'm on their panels. I'm sure you know, Everett, how those panels work. A union and an employer have a grievance they can't settle at the third or fourth step. They write a joint letter to either one of those two agencies and ask for a panel of arbitrators. Most union contracts provide that there'll be a panel of 7 names sent by Federal Mediation Conciliation or AAA, and then the parties strike one name at a time. So each gets 3 strikes. So finally one name remains, and you're the arbitrator. And that's one of the reasons why the courts rarely uphold an arbitrator's decision, because the courts say, look, you chose him, you picked him out, don't tell us your problems. Unless your decision is very arbitrary and capricious, the courts will not upset an arbitrator's decision. The steel workers in 1964 had 3 famous cases. They call it the trilogy. I forget the names of the companies. I knew them when I was with the board, but they made the basic law for arbitration in the United States and settled that point that you chose the arbitrator, you're bound by his decision in 999 out of 1,000 cases.
Well, I'm going to have to cut us off. We've used up the half hour already. And I'd like to say to our audience that we've been interviewing Mr. Thomas Bracken, who's a retired judge and is currently an arbitrator, and is also currently an instructor in the Labor Studies program of Dundalk Community College. And we urge you to get in touch with us because we're interested in you, we're interested in college education, and we're interested in working class people. Watch Labor Update. We'll be on again soon.